So in federal court, unlike in state court, there are no traditional pleas where a specific sentence is negotiated with a prosecutor. Every case in the federal criminal justice system that results in a plea deal or in a conviction at trial does proceed to a sentencing. So at sentencing, the judge is going to take basically three different things into account. And what the judge is going to consider is, first and foremost, what the position is of the United States Probation Office. After somebody enters a plea deal in federal court, within a few weeks, they're going to have something called a pre-sentence interview. Their counsel has a right to be present, and I'm always present when my clients are questioned by probation. They're not asked so much about the case, but they are asked a significant amount of detail about their personal life and their finances. The judge is going to receive this pre-sentence report, which is drafted based on the pre-sentence interview at the time of sentencing. The judge is also going to receive any written submissions, which are called sentencing memorandum, on behalf of the defense, and any submissions that the government might provide. Now, in every case, it is crucial for a defense attorney to file a sentencing memorandum. What that memorandum entails can vary, but the main focus is, and the main goal is, we are providing information based on both the United States sentencing guidelines and the United States Sentencing Code, or what's commonly known as the 3553A factors, as to what is a reasonable and appropriate sentence for our client. So we are first arguing the guidelines. The guidelines are advisory, not mandatory. The guidelines are based on essentially a point calculation. You start with a base offense level depending on the charge. For example, wire fraud, you start with a 7. Then depending on the amount of money that is alleged to have been lost, the points go up from there. Then you have certain enhancements, such as if there was obstruction of justice, if the individual was a leader in a conspiracy-related case. And then you also have reductions as well, such as acceptance of responsibility and cooperation are two very common ones. At the sentencing hearing, ultimately, the judge is first going to decide and hear argument about what the guideline range is. He or she will rule on the guidelines, and then we get into what is known as a variance. That is the 3553A factors. That is more or less everything about a person and about the circumstances of the case that warrant mercy. So we are relying on those 3553A factors to talk about the client's life, their background, their charitable work, their family, their mental health, their physical health, what they've accomplished in their life to essentially paint a picture to the judge that this person might be here because of what was their worst day or their biggest mistake, but you have to take that in the context of their entire life. So a judge is going to consider all of that at sentencing, and ultimately, it's the judge's responsibility to issue a reasonable sentence.